Welcome friends to this AEFC part 5. Argue in English fluently and confidently, part 5. In this special part 5, we will see the one important grammar book. I will give you one important grammar book of near about 480, near about 500 pages in PDF format. So that book will be helpful to you always in future for grammatically mistakes we are regularly uh, happen to through us, so we can correct that mistakes like that. And in this episode I will give you original one lecture of Nani Palkewala's original lecture, and that lecture was before Keshwananda Bharati case, and when the constitutional amendment 24th and 25th constitutional amendment was in process in the parliament. In that era, Nani Palkewala had given one lecture at Madras. Nowadays, that city is called Chennai, but earlier that Chennai's name was Madras. So that lecture is very valuable lecture. How fluent he is in English, how sequentially he is speaking, why Nani Palkewala is my guru. So everything you comes to know through that lecture. I will show you that lecture today. I will give some glimpse of that lecture. I will share you some my lectures also on YouTube for your performance, for better performance. And most important, that means SLP of that particular High Court order, Sanjeev Kumar High Court order, which I have given you in part 4. We have already we have discussed that High Court order which comes from Punjab and Haryana High Court, and how to guide that person and how to take that matter. Everything we have seen in part 5, part 4. And now, after getting that matter, how we draft the SLP and full bunch. So I will show you the SLP, full bunch, annexures, and everything. Okay. And argument point, we will discuss of this SLP argument point, important point in next part. I will discuss you today only SLP, full format of SLP. I will give you that. So let me close this WhatsApp because unnecessary message ringtone will be disturb us here. As usual, we'll start our program with tense. Now, all our 3 tense, each 4, that means 12 tenses we have covered. Now, in every episode, we have to take one legal verb and use all these 12 tenses. So it is our initiation of each part. So I will take one verb, initiate. Initiate means start, begin. So it is a legal word, initiate. I'm initiating drafting, I'm initiating argument, I'm initiating the study of new coming laws. So initiate means to begin, to start. So how we can use this initiate in these 3 tenses and subtenses 4? I will give you one glance. Write down it on paper and practice with 4 to 5 different verbs, which I have shared you in part 1. List of 1000 legal verbs I have already shared you, and you see that list and take any 5 verbs and complete this homework till next part 6. So, initiate. Original form is initiate, past tense initiated, and past participle initiated. And if we join ing, then initiating. Okay. Then present tense. I will cover all 4 subtense of present tense. I initiate, we initiate. You initiate, you initiate. He initiate, she initiate, it initiate, they initiate. This is simple present tense. Now continuous present tense. I am initiating. We are initiating. You are initiating. You are initiating. He is initiating. She is initiating. It is initiating. They are initiating. Now, perfect present tense. I have initiated. We have initiated. You have initiated. You have initiated. He has initiated. She has initiated. It has initiated. They have initiated. Present continuous perfect tense. I have been initiating. We have been initiating. You have been initiating. You have been initiating. He has been initiating. She has been initiating. It has been initiating. They have been initiating. Now, past tense. Simple past. I initiated. We initiated. You initiated. You initiated. He initiated. She initiated. It initiated. They initiated. Continuous past tense. I was initiating. We were initiating. You were initiating. You were initiating. He was initiating. She was initiating. It was initiating. They were initiating. Perfect past tense. I had initiated. We had initiated. You had initiated. You had initiated. He had initiated. She had initiated. It had initiated. They had initiated. Continuous perfect past tense. I had been initiating. We had been initiating. You had been initiating. You had been initiating. He had been initiating. She had been initiating. It had been initiating. They had been initiating. Now, future tense. Simple future tense. I will initiate. We will initiate. You will initiate. You will initiate. He will initiate. She will initiate. It will initiate. They will initiate. You can use shall in place of will also. Next, continuous future tense. I, continuous future tense. I will be initiating. We will be initiating. You will be initiating. You will be initiating. He will be initiating. She will be initiating. It will be initiating. They will be initiating. Now, continuous perfect future tense. I have been initiating. We have been initiating. You have been initiating. You have been initiating. He has been initiating, she has been initiating, it has been initiating, they have been initiating. Only 5 to 7 minutes required to cover all 12 tenses with any one verb. So repeat this by taking 5 different verbs from that list of 1000 verbs which I have already provided you in part 1. You should have each part study material. You should have in different folder. I am sharing you that every time, every week, and at the end of the part. Now, we will see one that important book which I am sharing you today, that is grammar book. Let me share you that grammar book. See, this is a, so I have already put here folder. See this folder, AEFC part 5. The part 1, part 2, part 3, part 4, part 5. And that part 5, this is grammar book. Yes, I'm sharing it now. See, this is grammar. Why grammar book is needed to refer, even though you will become a highest chairperson of any judiciary like High Court judge, Chief Justice of any High Court, or Supreme Court judge, or Chief Justice of Supreme Court, even though when you think fit, that time you always used to use grammar book. So this grammar book is very, very good for you. And I am sharing you its PDF file. This book has the following feature. All of the essential point of English grammar are covered. Each point of grammar is clearly explained and is illustrated by examples. For every important point of grammar, one or more exercises are provided to make it easier to learn and remember the material. Answers for the exercises are provided. A summary of uses and formation of English verb tenses is given for easy reference. Grammatically determined rules for spellings, pronunciation, and punctuations are included. Grammar of North American English is emphasized because this is foreign writer book. Grammatical differences between formal and informal English are pointed out. So these are the features and these are the topics. I will read the heading of the topics. The use and formation of the English verb tenses. The active voice of the verb to show, the verb to be, and passive voice of the verb to show. Common English irregular verbs. So verbs here also covered by these books. Chapter 1 consists the simple present of the verb to be, grammar, verb form used like that. Exercise is also given. Negative statement, negative questions, tag questions like that. Affirmative sentences, simple present. Then chapter 2 is simple present of verb other than the verb. Like the chapter 3, present continuous. Chapter 4, the present perfect. Chapter 5, simple past. Chapter 6, past continuous. Chapter 7, future tense. Chapter 8, conjunctions. Conjunction or with the auxiliaries of the word. Conjunction like the word, which word is joining two sentences. That word is called conjunction, like and, like that. So that is given here. The subjectives. Then model verbs in chapter 10. Chapter 11, transitive and intransitive verbs. Chapter 12, the passive voice. Chapter 13, the formal plurals. Chapter 14, singular countable nouns. This grammar book is not according to the syllabus of school. This grammar book is written according to the mastery on the English language in writing as well as in spoken English. So this is a practical approaching grammar book, not theoretical approach is here. So this is a special feature of this grammar. Chapter 15, plural countable nouns, uncountable nouns. Chapter 17, noun indicating possession and compounding subject. Chapter 18, personal pronouns. Chapter 19, other pronoun. Chapter 20, determiners. Chapter 21, adjective. Daily you read one chapter, or one chapter 2 days you can give for one chapter, and complete with its exercise also. Chapter 12, adjective used in comparisons. Chapter 23, adjectives used in comparison, part 2. That was part 1. Chapter 24, adverse position in sentence. Adverse position. Chapter 25, adverb of manner and adverb used in comparison. Chapter 26, prepositions. Chapter 27, phrasal verbs. We are using phrases. So phrasal verbs are there. Conjunctions. So these are the total 28 chapters. And total how many pages are in this book? And very simple language, very lucid, simple language with different examples. Okay, everything is given. See, 486, 487, 488 pages are there. So this is the gift from me to you all. I will share you after the completion of part 5 instructions in our regular WhatsApp group. Now, let me share you the SLP. Try to remember what was that matter. That matter was related to the suspensions of sentence. That particular accused sentenced 10 years imprisonment, in some cases 7 years, some cases, and concurrent he have to go behind the bar, concurrent 10 years. But what happened before completion, half sentence also, and before completion 5 years, before that, Punjab and Haryana High Court has granted him suspensions. So main victim is argued. So when he agreed, that time she have the locus standi. Locus standi means, locus standi is a Latin word. Locus standi means in which authority you are approaching to the court. Because in criminal matter, specifically more than 7 years imprisonment in that such type of criminal matters, prosecutor is state. So state, that means Sanjeev Kumar versus state. Such type of appeal was in High Court. And now victim Geeta is coming to us. We guided her. We fixed the fees, everything we discussed in part 4. If you don't remember, just go in part 4 video, run that video of this particular part, and then come here. And Geeta gave all the document, everything. And after receiving all document, how we drafted that SLP. Okay, criminal SLP. And what is the purpose of this criminal SLP? Which suspension of sentence has given by Punjab and Haryana High Court, we have to set aside that suspension, and that man again should go behind the bar and complete his imprisonment, complete his punishment. Okay, so that is our purpose. And I argued this case, that this case Supreme Court admitted everything. We will discuss argument point, we will discuss the notice issue order, everything in part 6. So sequence is this. In last part, we have seen the High Court order. Then High Court, after getting High Court order, we advise client how to advise clients. We will see all these things. Now client has sent us all the documents properly, and my drafting team has drafted that, yeah, as per my instructions, and I argued that case. Now, in this part, we have to see that full SLP draft. See, here is full SLP draft. Let me open. Here, title is changed. Cost title is changed because victim is here main petitioner. And who is the respondent here? State of Haryana and all the others. Others means Sanjeev Kumar. And Geeta is victim. So see how the locus standi, because he is victim. Let me share. See. No Harya, no hurriness. We have to go in depth to see the perfect SLP format. And you will see all lower court documents in this. So you can learn FIR, you can learn charge sheet, you can learn trial court order, you can learn here High Court order, you can learn all the lower court orders. See, this is a index. These are the annexures, synopsis, B2V, impugn judgment, that judgment which we have to challenge in Supreme Court, that judgment is called impugn judgment. 1-2 page. Special leave petition. Actual our SLP is from 3 to 16 pages. Appendices, section wise information is on 17 page. Annexure P1. In Annexure P1, true copy of FIR. Number 219 dated 25/5/2018, registered with police station, Old Faridabad, Haryana, under section 323, 324, 325, 307, 506 of Indian भारतीय दंड विधान, भारतीय दंड विधान अभी निकाल रहे, they are removing that name. and now they are converting Bharatiya Nyaya Sanhita. So no purpose of giving punishment, purpose is to give the justice proper. Meaning is same, effect will be same, but the title is different. I will arrange one Nani Palkiwala program on these three laws also, which are going to change in near future. So attend that program also. So part one is FIR. Part one, P1, annexure P1. Because we are petitioner here. When respondent files the counter affidavit, so whatever document he will join to his counter, that is written statement, that annexures will be called as R1, R2, R3, like that. Because R is for respondent. Because judges have to take both the things, original petition and counter. So P1 is the annexure of petitioner, and R1, R2, R3 are the annexures of respondents. So annexure P2 is related to true copy of relevant extract of the discharge summary dated 1/6/2018. Discharge summary is on page number 21 to 27. Annexure P3, true copy of order dated 7/12/2018, passed by the Honorable High Court of Punjab, Haryana at Chandigarh in CRM M so and so number 2018, that is page number 28. Annexure P4, true copy of judgment of conviction and order of the sentence dated 7/5/2019 and 9/5/2019, passed by the additional session judge. LD means learned additional session judge, Faridabad, Haryana, in session case, like that. So in one SLP, you can learn all these things. When I will show you civil matter, civil SLP, that time you will learn all earlier course proceedings in that. When I will show you army matter, that we will learn to all army tribunal, every order you can learn. This is a very good chance, friends, in our program to learn all these things with the art of argument. Then annexure P5, true copy of order dated 18/1/2021, passed by the Honorable Punjab and Haryana Court. Then P6, true copy of CRM number 95, like so and so, dated, filed by the respondent number 2 before the Punjab Haryana High Court, 79 to 92. Annexure P7, true copy of order dated 12/4/2022, passed by the Court of the Learned Judicial Magistrate First Class, 93/103. Annexure P8, true copy of the order dated 26/5/2022, passed by the Honorable High Court of Punjab and Haryana, Chandigarh, 1042-115-111. So such type of use study Supreme Court lawyer have to do. So our fees are maybe little bit more than High Court lawyers. But I am taking in Supreme Court very reasonable fees. And many lawyers are taking in reasonable fees, no doubt. Annexures P9, true copy of order dated 21/11/2022, passed by this Honorable Court in SLP. Okay, SLP. SLP means Supreme Court. This Honorable Court means Supreme Court, SLP, criminal, in 10489 of 2022. 112. This is IA, interlocutory application. application for permission to file a special leave petition, application for exemption from filing certified copy of the impugned order. And then FIR format. These are the technicals. These are official report of limitations. These are the pro forma of first listing. You go slowly at your home. Take the printout of all the pages. Not a big SLP, only 120, 130 pages may be there. This is the synopsis. Most important thing, synopsis. That the petitioner is filing the present special leave petition against the impugned interim order. Impugned interim order dated 26/12/2022. Because appeal is going there. Appeal is filed there by the respondent. But interim order passed and they have given the suspension after getting imprisonment only near about 4 years. 4 years and few months. And so victim get disturbed. How that accused, how that criminal is free now. So she is challenging that interim order of Punjab and Haryana High Court in this court. So against the impugned interim order dated 16/12/2022 passed by the Honorable High Court of Punjab and Haryana at Chandigarh in CRM number 9357 of 2022 in CRAS number 1887 of 2019. So main case is 2019, and in that case, these are the order passed by interim application, whereby the Honorable High Court allowed the fifth application. Fifth application means 4 application High Court has already rejected. And how suddenly they accepted fifth application? Here is a doubt. For suspension of the sentence filed by the respondent, number 2, and because respondent number 1 is a state and respondent number 2 is actual accused, and suspended the remaining sentence of the respondent number 2, Sanjeev Kumar, during the pendency of the criminal appeal before the Honorable High Court solely on the ground of custody certificate only, wherever it is now well settled that in case of post-conviction sentence, the period of custody undergone cannot be criteria of suspension of sentence. Some citation we have given in there. In Ali Ahmed versus State of Bihar and others. Criminal appeal, so and so. It is indeed true that the introduction of the first proviso to section 389, the law giver has stipulated a particular procedure to be followed in a matter of releasing a person who stand convicted of a serious offense as are indicated thereunder. Every law is intended to be followed. The fact that it is intended to be followed has been taken note of by this court in judgment reported in Atul Tripathi Supra. Supra means in this particular judgment that is discussed in upper part of that particular judgment. So Supra is there. Supra means as given above, like that. But if you see in this SLP above, you will not see, because this is the extract of this particular judgment. Okay, important para of certificate. Don't give citation in your pleading without important para. Always give citation with important para. Show to the judges how that particular judgment is relevant to your case. If you give only the name of citation, it is not sufficient. Sometimes respondent lawyer will take objection that a particular case is not relevant to this case. So that time you can convince judges, Lordship, I have given the para which is relevant to my case. So that para is important. Every law is intended to be followed. The fact that it is intended to be followed has been taken note by this court. I have already read this sentence. It is despite this that in the impugn order, it appears that the mandate of the first proviso has not been followed. Grant of bail post-conviction. Post-conviction, grant of bail clearly stands on a different footing from grant of bail to a under trial prisoner under section 439. So there is a difference between under trial prisoner, means before conviction bail, and after conviction bail. Yes, after conviction you can apply for bail. So this is the, yeah, or you can apply for bail, you can apply for suspension of sentences till the appeal concludes, hearing of appeal concludes, like that. But there are different grounds. The argument of the learned counsel of the second respondent that resort could have made been second proviso in section 389 is misplaced. That the second proviso speaks about it is that when a person is released on a bail under section 389, it is open to the public prosecutor to seek cancellation of a bail. Cancellation of bail apparently is intended to deal with the cases of transgress of conditions based on the conduct of the appellant. After the grant of bail, essentially, the mandate of the first proviso must be observed in its own right. We are therefore of the view that these cases, the impugn order, do not conform to the requirement of the law. We must observe that the High Court must be requested to consider the application filed by second respondent again. And what is given in Atul Tripathi and State of Uttar Pradesh case? So that para is also given. Okay, that para is very, very specifically to the point. I have given this third case as a reference. Okay, C case Sarin versus SBI Chandigarh. 2001 6 SCC 584. This honorable court held as under the legal position, therefore, like that. Then I have given one fourth judgment also. Period of custody not criteria to the suspense sentence. In a petition for special leave petition, criminal number so and so. Ram Naresh Singh versus State of Punjab held that. So all such type of drafting should be perfect. When drafting is very perfect now, that time your argument skill will get very positive result. So I am showing you the drafting in depth. So this is synopsis. Then this is the list of date. Hence the present. This honorable court allowed the appeal and allowed and directed to the High Court to consider the PIA for the bail afresh, preferably within 2 months, considering the mandate of law. It also asked High Court to decide the appeal related to the conviction of the sentence within 6 months. So here given brief as given here. 25/5/2018, the brief fact of the case are that on 25/5/2018, an information was received in the police station from QRG Hospital, Sector 16, Faridabad, regarding admission of injured Geeta in the hospital, upon which H.C. Durga Prasad, along with Constable Ravinder, reached there, wherein he received a medical regarding Geeta. A report should be there, reporting regarding Geeta, and sought the opinion of the doctor regarding the fitness of injured, as whether she was fit to make statement or not. The doctor declared the patient fit to make the statement. Thereafter, statement of the complainant injured Geeta was recorded, wherein she maintained that on 25/5/2018, when Geeta, wife of Gulshan, was at her parental home, she received a call from her husband Gulshan. Geeta was at her parental home, at her mother and father's home, and her husband was called. She received a call from her husband Gulshan at about 11 a.m. informing that Nikku Sanju Kumar got into a fight with him. So husband got the fight with Sanju Kumar and requested his wife to come to her matrimonial home. Upon reaching the home, the petitioner, that means complainant Geeta, saw that accused was using abusive language with her husband, namely Gulshan, and was also engaging in a scuffle. That scuffle which through which you can hit to anybody. When the complainant reached close to the accused, he picked up an axe kept near the door and attacked the petitioner complainant with the same on her head. Axe means kuladi, so axe on her head. Thereafter, she hit her twice on her right hand, due to which the complainant started bleeding profusely and fell on the floor. Husband of the petitioner complainant recused her on that day and took her to the hospital. The said dispute arose due to the fact that petitioner complainant was constructing her house, and the construction material were laying on the road, to which the respondent number 2 accused objected. Number 2 threatened Respondent number 2 threatened the petitioner complainant and her husband with dire consequences. That the FIR number 219 dated 25/5/2018 under section 323, 324, 325, 307, 506 of IPC, Police Station, Old Faridabad, District Faridabad, came to be registered upon the complainant of the petitioner Geeta. The version as mentioned in FIR is reproduced as. So that FIR version is also given. And this FIR copy is attached in Annexure P1. So similarly, detail date-wise happening is given here. Okay. In the prosecution witnesses given here. Then High Court, the High Court order P3. Already we have already in index. Already we have already in index, say P5, Annexure P6. And Accused was already convicted in FIR, so and so. What is the judge paragraph? Some paragraph we can mention here in list of text. So here it is completed. Now this is page number 1, impute order. That order which already we have seen in part 4 for giving guidance to the client. How her case is, actual sentence is more than 4 years and 11 months. And then this is the main special leave petition under Article 136 of the Constitution of India. I have already shared you SLP video of mine in part 3, I think part 3 or maybe part 4. You see that video again and again. And I have shared you Supreme Court procedure and Supreme Court rules. In that form 28 is the form of SLP. So according to that form, the SLP is prepared. Position of party in earlier court. In trial court, Gita is complainant. In High Court, Gita was not there, not a party. And before this Honorable, Gita is petitioner. Versus State of Haryana was prosecution in trial court, respondent in High Court, and contesting respondent in this Honorable Court. Sanjeev Kumar, who is accused in trial court, appellant in High Court, and contesting respondent in to here. To the Honorable Chief Justice and his companion judges of the Honorable Supreme Court of India, the humble petition of the petitioner about name respectfully, most respectfully show it. This is a regular technical languages. Main, you have to read question of laws. There should be a substantial question of laws, grounds properly. Whether the impugned judgment and order passed by the Honorable High Court is justified and legally sustainable under the facts and circumstances of the case. Whether the Honorable High Court err in suspending the remaining sentence of the respondent number 2, despite the fact that respondent number 2 attacked the petitioner Gita with a sharp-edged axe kulari and gave 3 blows, 1 on head and 2 on right hand, out of which 1 went empty. Whether the Honorable High Court erred in suspending the remaining sentence of respondent number 2, despite the fact that a team of neurosurgeon, 3 doctors, along with the orthosurgeon, operated Gita, and 2 major surgeries with implant were done to save her life for life of her head, forehead and right hand. Neurosurgeon Dr. Vikram Dua from ORG Hospital has given opinion about Gita's injury in head as a dangerous to life. That a medical board of 3 doctors team from BK Hospital was formed by the police to take opinion of MLR and discharge summary. Medical board had given the opinion that injury number 1, head, is dangerous to life, and injury number 2, that means on right hand, is grievous in nature. For whether the Honorable High Court is correct in not appreciating that learned additional session judge Faridabad void its judgment of conviction and order of the sentence dated 7/5/2019 and 9/5/2019 convicted with the respondent number 2 accused under section 307, 326, 506 of IPC and sentenced him to the undergone rigorous imprisonment for 10 years. whether the Honorable High Court err in the following the suspension of the sentence application of the respondent number 2 without considering the fact and circumstances of the case. So such type of question of laws are there. Then grounds are there. Grounds is also covered with case laws. Such type of high level efforts we are taking in this apex code. A, B, C, D, E, F, G, H, I, J, K. These are the grounds. L, M, N, O, P, Q, R. These are the grounds. Grounds for interim relief. Main prayer. Relief for interim relief. For argument purpose, we have to focus on question of laws and grounds. And there are two types of argument. One is admission hearing and another is after notice hearing. So after notice hearing is a main argument. But main argument you will get chance to argue when your matter is get admitted first. In lower court or in earlier court, trial court or maybe high court, sometime appeal, admission of appeal is very easy. But in apex court, it is not so easy. So when we get the matter admitted in Supreme Court, our victory is 90% guaranteed. And only 9% after notice. After notice, then when Supreme Court admit that and issue notice, so that time our victory is guaranteed here 99%. But 1% we have to live in the hands of the honorable judges of our Supreme Court. So this is the prayer, interim prayer, relief prayer. Here is my name, Jayprakash Somani, arguing counsel. Vivek Sharma, he's our AOR doctor. Geeta, this affidavit. Now, see the all documents properly. This is my purpose to show you. Because at home, whether you are studying it properly or not, I don't know anything. And I will not take your examination because this is not a certificate course. This is a live transformative course. If you really follow instruction given in each and every part, definitely you will get the benefit as you will be an excellent arguing counsel in your area, definitely. So this is the affidavit. These are the notarized affidavit. These are the appendixes. Appendix means in which section what is there. So no need to take the books then, because it is given on page number 819. What is in text section 307, attempt to commit murder, 326, voluntary causing grievous hurt, 506, punishment for criminal intimidation. This is annexure P1, FIR. This is the type copy. This is not original FIR copy. This is type copy because Supreme Court, all judges are near about above 60. So we should take the care of their eyes also. So 14 font should be there. Double spacing should be there. So suppose in such a format, the annexure is not there. So we have to retype that annexure for better understanding of the judges. So all these FIR are here again retype as per the need of our court. This is a P2 discharge summary. It is also typed. Now this is see the photograph. I have shown this photograph in admission hearing. Lordship, see the victim's injury. How deadly weapon used by the accused and cause serious injury. On her hand also, here on this side. Annexure P3, High Court's order. Annexure P4. So likewise, you have to say trial court order, punished order, everything you can study properly. You can. So this is the SLP. Now, as I promised, I will show you one Nani Palkhiwala, original Nani Palkhiwala's video. But video is not available, audio is there. I will show you some part of it.
Being guilty of contempt of Parliament. If you ask members of Parliament, kindly educate what are the fundamental rights, what their content and embed is, I wonder how many would pass the test. Now, this is not to pass expression on any individual who today may be the elected representative of the people. This is merely to make good my point, which is, fortunately, we have so much ignorance about our own constitution. It is almost unbelievable. The great saint once said, no democracy should enthrone ignorance only because there is so much of it. Almost not to introduce for the first time. Wants to say this, and mind you, it will become the law unless people.
Friends, listen this carefully. This is very great lecture. You will comes to know how this man saved our democracy. And after that, Keshwananda Bharati case was happened, and that case create basic structure doctrine. Parliament can change the constitution, but Parliament cannot change its basic structure. So everything you comes to know, I will share you every part, different videos that are lifetime useful video for you, for your vocabulary, for your understanding, and for your mastery on that particular language. So in very lucid, simple language, Nani Palkhiwala is speaking with audience. And on every budget, Nani Palkhiwala was used to give the speech in the big stadium near Bombay. Big stadium. Stadium was full. Vijay Merchant used to give introduction to of Nani Palkhiwala. And Nani Palkhiwala in flow deliver the speech on budgets. Dhirubhai Ambani, some big businessman are were in audience at that time. Such type of great personality was my guru, Nani Palkhiwala. So I have shared you that original, their one lecture in their original voice. So read it, hear it again and again. Try to understand it. Near about, I think this is 70, near about 70, 69, 70, 1969, 70, 71 period was there. At that time, this constitutional amendment was proposed. And for the awareness of the general public, that lecture was arranged in Madras. And that lecture was, somebody uploaded on YouTube. I got that lecture and I saved that lecture for you. So this is the gift from my side. And I will share you some my one or two my lectures also in today's part. So listen all this part. Let me summarize the instruction of this part. First, we have seen verb initiate in all 12 stanzas. Then we have seen grammar book of 486 pages grammar book, which will be useful to you for lifetime. And that grammar book is not on as per the theoretical aspect. That is as per practical aspect of spoken English and practical aspect of written English. So that grammar book I have given you. Then I have shown you the full SLP of that particular criminal SLP to cancel the suspension given by the Honorable High Court. And how that draft, how we mention the case laws with proper para. So everything is given properly. Such type of high level efforts we have to take in our court. That time we can admit this. So many lawyers are attached, High Court lawyer, District Court attached lawyer are attached with me to transfer their cases here because they know I and my team are taking high level efforts to admit each and every case. So this is the one example I have shared you that. And at last, I have shared you original lecture of Nani Palkiwala, which was delivered in Madras at that time, before the Keshwananda Bharati case, before the amendment was challenged, 24th and 25th amendment was challenged in the Supreme Court. So before that, amendment was proposed in that era for the awareness of general public. Somebody has arranged that lecture, and Nani Palkiwala, how he delivered that lecture. Somewhere he is giving some humorous touch also to his speech. Somewhere he is giving very personal feeling touch, like that. And when you read the Keshwananda Bharati case, that case, I will share that case to you in some part. Maybe I will share that case laws, Keshwananda Bharati case laws in part 6. Definitely, I will share you that case in part 6. You read that case, and wherever Nani Palkiwala was argued, that extract given by the judges there, 13 judge bench case was that. More than 1,000 pages are there. Only synopsis and summaries near about 48 pages in that cases. So how that case create a miracle in that era and saved our democracy, because no parliament can change the basic structure of our constitution. So what is the basic structure? Everything is given proper analytics. So I got one motivation after hearing the Nani Palkiwala's original speech and after reading Nani Palkiwala's a few judgments. So I get the motivation to write one book of the argument, pieces of argument of Nani Palkiwala, by taking extract from these different judgments and create one book. So that book will be available on Amazon and so on. To those who want to learn a proper argument, not only Nani Palkiwala, but we will cover some other stalwart lawyers' argument also there. and how they argue, how they give the examples, how they give the case citations, how many cases cited there. So such type of work in our apex court we are doing, friends. So this is the end of today's part 5. So enjoy part 5, enjoy instruction, do that homework, take mastery on language, stand in front of the mirror, try to read it loudly with your proper action, but no ego should be there. Okay, your voice should be a normal, but it should be a convincing, and it should be touch to the heart of the judges to give the decision in your favor. So such type of practice of argument every day, you should do that. So thank you. Thank you very much for attending this part 5. Thank you. Thank you very much.